registered 291 cases, including 98 non-Egyptian parties and more than 80 non-Egyptian arbitrators. For the year 2021, we've registered 83 cases, including 34 non-Egyptian parties and 18 non-Egyptian arbitrators. These kind of examples, and I can actually elaborate a little bit more. So for instance, since 2017, we've involved 135 non-Egyptian parties from the following countries. We have Austria, Bahamas, Bahrain, Bangladesh, Barbados, Belgium, British Virgin Islands, Bulgaria, China, Cyprus, France, Germany. I can go on. It's a lot of countries. Some of them European, some of them from the Americas, from Asia, from Africa, and the arbitrators. We have a huge list of arbitrators, more than 400 arbitrators from spanning over 60 nationalities in our center. These statistical figures, I really would like you to visit the website and learn more about it. So it's not purely domestic. We have cases in the English language. I can mention.
In terms of, may I ask, in terms of percentage when it comes to domestic and international, when it comes to the caseload at arbitration, you have figures in mind?
When you say domestic, you mean an Egyptian party versus an
Egyptian parties.
I cannot give a specific answer because even the shareholders in the Egyptian, when you say an Egyptian party,
yes,
it might be a company, but maybe the shareholders can be diverse and they can come from different nationalities. So I cannot give a very strict figure on it. But what I can say is that the number of cases we get can involve really a lot of parties, not even just the claimant and respondent. So one raises a case against the other. It could be more than one party. So I would say I cannot categorize it as a domestic case. But then again, we do work everything. So that's a good part of it.
Good. And in terms of managing the arbitration cases, what's CRCICA experience of that?
I'll say that, but I just wanted to mention, so basically our advantage at the center is that we have experience, right? Everybody can create new arbitration rules, and a lot of people can copy from each other. A lot of centers can copy from each other from the rules and so on. But it's not about the case law. So sorry, it's not about the rules. It's about how the cases are being managed, about how effective the center can be, in responding to all of the quick things and how they apply their own rules and how the director can be quite responsive. All of this counts. So we have, since we've been there for almost 45 years now, we have experienced counsels, case managers. We have also younger generations, so still and to keep up with the caseload and number of caseloads that we have, and they can all manage in Arabic, English, and French languages, which our rules are in, by the way, Arabic, English, and French. I just wanted to mention something regarding the values of the disputes. So we have, while up to half the cases in a given year will have a sum of dispute not exceeding $1 million, and of course, with the 4 devaluations that took place, the $1 million is now it's a big figure. It's almost now 47 million Egyptian pounds. So with that, I would say this figure, we're not exceeding 1 million. However, the center administers multi-billion-dollar cases. For example, in 2015, the total sum in dispute in a gas supply case reached almost 6.5 billion US dollars, representing a new record for the aggregate sum in disputes. We've witnessed an increase in the number of cases with higher sum in disputes. For example, CRCICA recorded a 153% relative increase in the number of disputes, with a sum in dispute exceeding $50 million between 2017 and 2021. So we have a lot of figures and numbers. And to support that, we have excellent hearing facilities. We invest a lot in this. So we make sure that we have, for the proper administration of arbitration cases. And I again invite you to go to the center's website and visit our hearing facilities to see the kind of facilities we have. We have hearing rooms, we have breakout rooms for parties. We have a lot of specificities for very complex arbitration hearings. So we offer reliable high internet speed, access, privacy and confidentiality, audiovisual equipment, or even food and catering. And I want to say something, just one more point. A lot of, since the coronavirus hit us, doing online hearings and the remote hearings is becoming really trendy. So a lot of centers are investing now in this to make sure that they stay with the trend, to stay with how difficult things are. And when I was still a counsel, I was working as a lawyer in an arbitration hearing, representing one of the parties in a CRCICA case in the year 2014. That was even before the coronavirus came to exist. We had a very interesting hearing. One of the co-arbitrators, and he's a very well-known UK arbitrator, who was in the hospital and couldn't come. And we could not postpone the hearing because it was a 5-day hearing. He could not come. We had 2 witnesses, or 3 witnesses who couldn't come either, and 2 experts who could not attend.
Okay.
And we did it all remotely, even with the
guy in the hospital did it from the hospital?
He did it from the hospital. They actually brought all the machinery
okay.
into the hospital room, and he actually did it. And he had the hearing, and we had excellent service back then. I would say 2014. So that's a thing that we accounted for at the center.
Interesting. Okay, and you've been telling me, speaking of technology and the facilities, you've been telling me before about a new system that you were working on applying, on digitizing everything, digitizing documentation.
Yeah.
Can you tell me more about that?
Yeah. So one of the things we're actually finding it very challenging at the center is the fact that we are requesting the parties to submit their submissions in hard copy. Why aren't you going with the trend and using the soft copy? We have online filing now applicable on the center's website, but it has a very specific set of rules that you have to abide by. However, the problem that we're facing is that the judiciary, so of course, when a party wins an award and wins a case and they have their award, they want to enforce it against the other party, they apply, they send a notification to the other party had 90 days to dispute it and to challenge it, try and set it aside before the Court of Appeal. Let's assume that it's an international case, so before the Court of Appeal. The Court of Appeal will look into the case and they will ask the Center to provide them with hard copies of the submissions and every single thing that relates to the case. That is a problem for us. We also have the other problem that the arbitrators themselves can actually request to have them in hard copies, to have the submissions in hard copies. So we are trying to work on something now to develop an online platform. It's going to take some time to get it done, but basically with this, we can actually make sure that we try and get from the parties just one hard copy and do everything online through an online platform created through CRCICA, and for everybody to upload their submissions. But this is a far-fetched project, but I think we can get it done hopefully soon after we make all the required testing. But our problem, for instance, the economic courts accept online filing. For them, it's acceptable. They do everything electronic. So if you want to provide the court with a USB or with, making a submission online, you can actually do that. But with the Egyptian courts of appeal, still that kind of technology is not that applicable. So you have the problem for the setting aside, and then you have the problem after the setting aside is ruled, it's ruled on it and it's rejected. Then you have the execution or the enforcement. Enforcement also requires the court to take a look into the files. They can access again to the files. So that's why we'll have to have at least 2 hard copies to provide for them. So that's the issue that we're facing. But hopefully through this concept that we're creating, even with our new rules that we have, we can still make this happen and apply. But still, it's a far-fetched project. So I hope we satisfy.
All right. And in terms of improving the regional position in Arab speaking, what can you tell me if you have the collaborations agreement, cooperations agreement, or generally a plan on being more regional?
Look, I'll give you first some of the international recognitions. So the center has been there since 1979. It's quite old. We've tried to press on a lot of levels. So for instance, we have the African Development Bank. They create reports every now and then. So they had one in 2014. They have one in 2022 specifically for the Cairo Center, only for the Egypt region, the Cairo Arbitration Center. They recognize us with all the neutrality. The reports, by the way, are on the center, so you can actually take a look into it. And they mentioned the neutrality of the center and the suitability of it and how it's really conducting the provision, the excellence in providing the conduct of important international arbitration proceedings and suitability of CRCICA to be chosen, and all of these things. And in 2022, in the report, they mentioned the Development Bank, and also the Global Arbitration Review, where the CRCICA featured in the Global Arbitration Review's whitelist of regional centers since November 2016, and we were recognized by GAR as the Regional Institution of the Year in 2013 and 2019 for arbitral institution that was most impressed. We have cooperation agreements signed, over 90 cooperation agreements signed. We're very active in this issue. We have a lot of partnerships. We use our center as a hearing facility for other centers as well. So for instance, if there's an ICC case or the Court of Arbitration for Sports, if they have a hearing and they want to host it in Egypt, they come and host it. And we're using our facilities, even though it's the applicable rules are not our case. We're not administering the case, but we can host through our facilities these, and that makes it easier for the parties to stay within Africa instead of having to pay a lot for the hearings abroad. We have signed cooperation agreements with some of the most major arbitral institutions such as the ICC, the ICSID, the STC, the AAA, and we are very happy to always expand on that matter. So that's one of the other things that I wanted to mention.
All right. I will get you. No. I don't. We will go back to the arbitral awards, but I want to go back again to the cooperation agreements. You said that some hearings are being done by different arbitration centers like ICC and stuff like that. But you're just, in this case, you're just like the venue, you're just the place. Okay, so no intervention, nothing.
It's fully administered by the ICC or by the CAS or whichever center that we have, but they can use our facilities, and we were very happy to provide them with this option. And if we have a case also abroad, we can actually request through the cooperation agreement to host the case at their center. So it could happen vice versa.
So it goes both ways. Okay, interesting. All right. So finally, speaking about the arbitration awards, you told me that you publish your arbitration awards online.
Yes.
All of them, part of them. How can we access it?
Yeah.
If we want to access this kind of information.
Sure. So again, I ask you to visit the Cairo Center's website. We have a section where it's called CRCICA Arbitral Awards. So we have some of the arbitral awards that are being published. Soft law is very important. I think the most important thing is that others can access and understand the principles, the legal principles that are endowed within each arbitral award. And that is what they care about. It's not about caring about the name of the parties or about the counsels or the arbitrators. So we have a confidentiality clause, article on confidentiality in our arbitration rules, which gives us a right to publish arbitral awards, but without disclosing any of the names of the parties in the council. So we abide by that. But also, more importantly, it could happen that if you mention within a certain industry, within a certain country, that it's on a certain field. For instance, if I say telecommunications, I think four telecom companies are there in Egypt dealing with it. So it's easy for you to understand and know that this which party we're talking about, which of these companies we're talking about, especially if you read the facts. So even these little figures, this little data that can actually give away the identity of this telecom company or whichever company in Egypt, we remove it and we can actually change the name of the industry. Again, what we need to focus on is the principles, not about who did this and who did what. So we are very, very, very active in this. So we regularly publish to guide users in applying our arbitration rules as well. And we maintain the confidentiality, as I mentioned. We publish with Kluwer Arbitration, with Jus Mundi. We actually publish some of our awards as well in our Journal of Arab Arbitration. We mentioned some of the legal principles within them, and the International Journal of Arab Arbitration and others. and ICA. So I'll give you an example. We published a couple of years ago with the ICA, the International Council for Commercial Arbitration, the yearbook awards, which are considered amongst the best awards in the world, issued by an arbitral institution in amounts surpassing billions of US dollars. Not to mention that such awards include some of the highest calibers of arbitrators, which we do not disclose their names, of course, showing the prominent place that CRCICA has achieved as an arbitral institution in the global arbitration scene since it came to exist over 45 years. So that's one of the things that we care about. We care about sharing the soft law without disclosing any of the parties' names.
All right. You mentioned as well there's new CRCICA rules. Can you tell me more about it?
Sure. So the CRCICA arbitration rules. So initially, like I mentioned earlier, to gain the credibility of the users back then in 1979, when following that in 1985 when the UNCITRAL arbitration rules were created. So we have 1976 the UNCITRAL arbitration rules. We have the 1985 model law, which our Egyptian arbitration law is based on. So the 1976 rules, when they were created, the Cairo Center wanted to follow suit and based its arbitration rules on them. And of course, the UNCITRAL arbitration rules were updated in 2010, following that a couple of times. So the center stays, we based our rules on the UNCITRAL arbitration rules with some changes regarding the institutional perspective of the center, because it's not ad hoc as the UNCITRAL arbitration rules. So we followed suit. We had our rules published in several, we made several editions, such in 1998, 2000, 2002, 2007, and 2011. But now we issued our new rules on the 15th of January 2024. They're available in English, Arabic, and French. And the Cairo rules, arbitration rules of 2024, they are somewhat based on the UNCITRAL arbitration rules, but to gain the credibility back then when we created the center for the users to use the UNCITRAL rules that are based on the UNCITRAL arbitration rules, it was to get them to use the center and to make sure that they are to feel credible and to feel safe that we are using international rules with certain standards. But now there's a lot of updates and changes and developments in the scene that leads us to we have to stay put. You have to stay in line with developments in our arbitration rules. We are now more robust in our content to respond to all the evolving needs of the user of the commercial arbitration. So we do not we cover new matters that were never covered before. And other arbitration rules keep updating the rules regularly. So, for instance, what I want to show to you as something of a great effort that was done. The 2011 arbitration rules, the users are used to it. It's been 13 years. They are used to it and they don't know if we made a change to the rules and it was a lot of massive change, they wouldn't know what we changed. So we have on our website, in the CRCICA arbitration rules sector, you will find a part where we have a comparison between the 2011 arbitration rules and the 2024 rules in all three languages, English, Arabic, and French. We mention what has changed. We mention where we changed this and where it went in the same document, so our users would feel comfortable and understand that to guide them on what we changed. We provide a lot of changes in the new rules, such as the online arbitration filing, the remote hearings, the law applicable to the arbitration agreement, consolidation of arbitrations, early dismissal of claims, multiple contracts. A lot of changes happened in the Cairo rules. And we what I want to say as well is that the drafting of the 2024 arbitration rules started by a CRCICA internal team. I was part of it. We did a very thorough comparative study between all of the most renowned arbitral institutions in the world. We understood their guides. We read through why did they make the change, what does it mean, and we went even through the original working group of the UNCITRAL working group that created the UNCITRAL arbitration rules to understand the backgrounds of the centers that were participating, the national reporters who were attending these working groups, and we checked a couple of books to understand the essence of why did they create and what was the other centers' views, to understand why we need to make the change. And we built on this as well. We have a lot of experience in all of the practical issues and the problems that the center keep facing on a daily basis through the management of the case managers in their cases. We understand the problems that we were facing, and we also took this into consideration, along with the practice notes that the center keeps publishing, relating to how the center applies certain rules that are, it's like a مذكرة إلحاقية, it's like the explanatory note to the rules regarding certain practices that the center would do. So this group of people that work together, there are other members as well from the advisory committee of the center, the board of trustees of the center, and we worked together for, the practitioners that worked on it. We worked for almost 4 years on this project because it's a massive change, and we had to get the experience from the views of the arbitrators, from counsels, from the center, and eventually we came up with the rules, and we showed it we made the public consultation to everyone to give us their feedback on the rules, and eventually we published the rules. So I would say it's a lot of work, a lot of pioneer changes. So the comparison that I mentioned earlier would actually help the users to understand what the changes we made, and we keep, of course, hoping to publish guides and possibly other practice notes that can fix and help in the management of the day-to-day basis.
All right, and speaking of the rules as well, we should mention as well that the bigger ecosystem, which is the Egyptian arbitration law, which we were having a separate roundtable on that today. And since we're still waiting for the mid-late user traffic, someone from Irada to give a presentation about, or an introduction about the roundtable as well and about Irada. So I guess I want to thank you first of all, and thank you very much for your explanation, and thank you very much for bearing my questions. And I guess we will have a bit of a change in the schedule. We will start with the investment banking panel afterwards. So stay tuned, that the next panel is really interesting. Thank you very much. And if you have final words.
Yes, I just want to say one last thing. So at the center, I mentioned a lot of things that we've been doing, but I didn't mention anything regarding events and trainings. I think it's very important that the younger generation, and even judges and even lawyers, to be educated more in the center. So we are always hosting seminars, symposiums, and training to explain more on arbitration and about dispute resolution in general within the center. So if you follow our center's website, and we can actually send you emails if you like to be kept in knowledge with everything that we've been doing. We have a lot of things that we've been doing. So we have, for instance, one of the things that's very interesting. We've done so far 7 rounds on the training course of comparative commercial arbitration theory and practice. This is done jointly with the CIR Egypt branch, and the Cairo Center is the host, the CIR Egypt branch. This is for successful candidates who actually pass this course. They can qualify for the Chartered Institute of Arbitrators to become members, and this is a very prestigious thing. And I think I would encourage everyone to try and do that if they didn't. It's really full of knowledge and full of information. So, and we give discounts also for training fees for members of judicial bodies and for universities and professors. So I think that's one of the trainings that we do. We do a lot of trainings, but this is one of the ones that I really recommend. And finally, we have the Sharm el-Sheikh conference. I don't know if most of you heard of it. We do it. We've done so far 8 installments of it.
It's once every 2 years.
Once every 2 years we do it. We discuss the role of state courts in international arbitration. We bring experts from all over the world to come and speak on this event, within this event. And it's really also massive. So we discuss it from a comparative style, each one coming from the jurisdiction, discussing certain things relating to how the courts can actually assist arbitration and vice versa. And we make sure we try also, I don't know if you know that as well, the final remark I will make. the judges can actually apply, they can get a request, they can apply a request to become arbitrators and work as an arbitrator in a specific case after they receive the acceptance of the judiciary on that matter. So it's actually possible for them to act as arbitrators while they're still judges, but only if they get the permit to do so for a specific given case. So that actually is very good for the judges to train more on arbitration and learning about the procedures. And that is something that we care about. Thank you very much.
Thank you very much, Dr. Hafez. Thank you.
ضرايب على القضايا اللي هم بيشتغلوا فيها.